I would, Mr. Ematom, you're set for a suppression hearing, December 12th. You have, at a minimum, got to look at every single piece of evidence that's out there before you even go to your hearing. It would be a fool's errand to go to this hearing without looking at every shred of evidence that's out there, because you have to know what they have and what they're going to use to prove. Today is time set for discovery. It is November 20th, 2024. It's approximately 11:49 in the morning. I'm going to have you guys announce yourselves for purposes of the record. Please state.
For the state, it's Amber Nathan and
Morgan Harmon.
Judge, hold on. Can you have him come over so that I can see him? Amber, right here. Yeah. Okay, go ahead. State it again.
Amber Nathan for the state.
Morgan Harmer for the state.
So what we have here today is we have Mr. Ematom. He is charged with unlawful carrying of a weapon. I want to say today is our third setting, or fourth. I think it's our fourth setting today. Mr. Ematom has chosen to represent himself. I have done a Feretta hearing.
Buckle up, guys. Today we're diving into a courtroom clash where a defendant tries to go solo in a serious suppression hearing. The judge opens with a blunt warning, telling Mr. Imam it's reckless to step into court without reviewing the full evidence. It's a tense start, and you can feel the pressure already mounting in the room. Right from the jump, the stakes are sky high, and there's no room for mistakes.
Found that he is and can represent himself. Mr. Ematom, are you sure you don't want a lawyer to help you out? Do you want a lawyer to just sit standby to be able to answer any kind of questions? Okay, you still want to represent yourself. Understand that if any time you would like a lawyer, I'm happy to provide you one at no cost to you that can advise you in any way that you may. So that is always at your disposal whenever you need it. At the last setting, we were working on discovery to see what was available. And the only thing, if I remember correctly, the only thing as way of discovery was an offense report that was in.
So, Your Honor, the discovery is in. There is a video. There is a body cam and dash cam that's in. The state has tried to reach out to Mr. Ematom to schedule a time for him to come in to review this discovery. It is the state's policy to not give this discovery out of the office to pro se defendants. He is here today. We can coordinate with our investigators for him to come and look at it, what we have. There is also a motion to suppress filed on the same transaction felony out of this, and that is scheduled for December 15th, I believe, or 9th.
December 12th is my next.
December 12th, okay.
December 12th.
Are you representing yourself in the felony case as well?
Yes.
Okay.
Judge Lacayo did find him competent to do so, and we are having a suppression hearing on the 12th of December for that case.
Okay.
So if the evidence is suppressed, both cases would be resolved based on the search, because unlawful carry is tied to our transaction. It is a commission of a felony offense. So if our case goes away, your case goes away.
Are you upstairs as well on his case upstairs?
I'm on the felony case, yes.
You're on the felony case. Okay, great.
I know the last time we was here, I did the suppressed evidence. Are they doing the misdemeanor and the felony together with the suppressed evidence? Because I emailed, I don't know if it's Anna or I have it on my email. I emailed Friday, tried to review the evidence, but I didn't get a response. I got a response to come tomorrow at 1:30. I didn't make it in town till.
All right, guys, here's where things start spiraling. Mr. Imam insists on self-representation, and the judge tries, again, to talk him out of it. But what really stings is the revelation that key evidence, including body cam and dash cam footage, hasn't been reviewed by the defense. The prosecution stands firm on policy, and now the judge is clearly worried this case could collapse before it even begins. The courtroom tension is building fast.
Yesterday night.
So the defendant emailed me on Friday, and he reached out to review the evidence. I requested a cause number. He provided the cause number, and I sent on Monday at 7:20 a.m. Would tomorrow work to review the evidence? Please let me know if you have a preferred time. I'm available anytime after 1:30 p.m.
Here now? Is it possible to do it now?
Let me coordinate.
Perhaps later today, since he's
Later
here.
today. Let me go talk to our investigators, make sure they can supervise him. And
You're here now.
Yeah.
I would, Mr. Ematom, you're set for a suppression hearing, December 12th. You have, at a minimum, got to look at every single piece of evidence that's out there before you even go to your hearing. It would be a fool's errand to go to this hearing without looking at every shred of evidence that's out there, because you have to know what they have
Yes.
and what they're going to use to prove, you know?
Last said, and they did go in the back room and let me see whatever was like the report that was typed up and everything. So
Yeah.
I was able to.
That's just an offense report. But here, he's saying there's body worn camera.
body-worn camera, there's another video as well that was uploaded as evidence. And then I believe there was an image of the stolen check that was.
You want to talk to your investigator now? And
Yes, I'm good.
can you stay here and perhaps maybe like at around 2:00, meet them at the office and then go through all the evidence then? Is that okay?
Now it gets messy. Emails, miscommunication, and missed deadlines. Mr. Imam claims he tried to review the evidence, but didn't get a response in time. The prosecutor pushes back with exact timestamps, proving their side of the story. The judge, stuck in the middle, scrambles to salvage order. Everyone's talking, but no one's listening, and the cracks in the defense are starting to show loud and clear.
Yeah, I can do that. I can.
You're here.
I mean, yeah, I can do that now.
If tomorrow,
Might as well-
if you want to come in tomorrow morning,
Yeah,
that gives us time, but he has to confirm with us because ADA Harner has emailed him and he has to make that call. Like he can, I don't know, the body cam could be 4 or 5 hours of body cam because there's multiple body cams. I don't know if our investigator is going to stay till 7 o'clock to review body cam today.
That's a good point. So
So
why don't
if you're available tomorrow morning,
Yeah, that's
at-
we do it tomorrow morning?
Yeah, that's fine. Also, are they gonna have the medical record for the hemp? Are they gonna have the?
So that is the one piece of evidence we're still waiting on, Judge, is the lab for the marijuana.
check the charging instrument.
It's, I'm telling you, it's based on it.
That takes a long time. Mr. Ematom, it takes a long
I
time.
do have the receipts from, because they had Montana Doyle that was claiming that. I do have the receipts and she was my witness. That it said that she was claiming that. It said it in the report. So my witness could come and do the testimony or whatever.
But that's at the hearing.
Okay.
That's it. You do that at a hearing. You don't do that here as part of just evidentiary sharing, right? It's not, no one takes testimony now. No one decides.
Last one, they said she could do it with the clerk. When I did have her here, they said that the clerk could,
You mean just filing an affidavit?
or whatever she needs to do to say,
I mean, I can't tell you. You're representing yourself. That's why you usually have lawyers that kind of guide you on how to get evidence admitted, what kind of evidence gets admitted. I can't give you legal advice and they can't tell you either.
yeah, they said I could submit it to the clerk. That's what they said. The witness could come to the clerk and do
Who is they?
the work.
We didn't say that. All I said is that if you wanted to file an affidavit, yeah.
This is where urgency meets delay. The court offers a lifeline. Review the evidence either later today or early tomorrow. But there's a twist. The lab results on the marijuana haven't even come back yet. Mr. Imam tries to defend himself with receipts and a potential witness, but it's clear this case is skating on procedural ice and time is slipping fast. The whole case could hinge on evidence no one's seen yet.
Something like that. But
I have to do that.
so can you talk to your investigator, see
Yes, I'm gonna do that
tomorrow, perhaps like at 9 o'clock in the morning?
9 o'clock.
So he goes at 9 o'clock. That way it's early. He can stay for as long as he needs to do it. And then if you guys can also provide me with an address of where he needs to go, what floor, perhaps give me a contact name and number just in case as well. So of your investigator. That way, if he should have any issues, he has a contact to be able to speak to someone as well. Because if he tries to go through the regular phone system to talk to man, he'll be beating his head against the wall. Okay, so just hang tight with me, Mr. Ematom. I'm going to have him talk to the investigator, see what time, make sure 9 o'clock tomorrow is good. We'll find out where you need to go. We'll give you a sheet of paper with time, location, and a contact for you. You go review everything. Our case is now 11/20. Today's November 20th. Do you want to set it for after the suppression hearing?
All right, here comes the confusion bomb. Mr. Imam believes he was told he could bring in a witness through the clerk, only to have that completely shot down in court. The judge makes it clear, no one's giving legal advice here. If he wants evidence admitted, he's on his own. This isn't law and order, it's real life, and without a lawyer, he's clearly struggling to navigate the rules of the game.
Since you guys are going to do that over there?
And honestly, I don't even think that the marijuana was sent to the lab, Your Honor. So
I put in a lab request, Judge, myself. I'm not sure if the officers provided it, but I put in a lab request.
okay, if you put a lab request, like I don't know when the.
We'll cross that bridge when we get there. If the officers aren't doing what they're supposed to be doing, go! You know how I feel about that. So,
Just wait.
how do you feel about that? We'll set this case maybe one day after your hearing upstairs
Well,
on the 12th.
yeah.
And like they said, if you win that hearing, this case goes away.
Yeah.
If you don't win that hearing, then we'll deal with this case the day after and see how we move forward. Okay?
Okay, thank you, Your Honor.
All right, so we're off the record. All right, so just hang tight for me. I'm going to get all the information for you and then just look at everything that's out there. All right, got to, okay? And now he's still consuming alcohol, Mike.
That's what I'm saying. He's here to tell you, I don't believe that's the case. He swears up and down he didn't. He puts,
I have a scram.
I understand that. And he puts some like crazy amount of makeup on him and the alcohol, I gave you the pictures of it also. It's called alcohol, what's it called? Hang on, he can explain it to you, but I have it here.
I have pictures of,
The nature of alcohol can be mistaken for alcohol consumption. I know.
I have these pictures. It has no date. It has no,
To give you context to it, I have the dates here. Those are just pictures of the close-up makeup, but he was DJing on those particular dates. And I have it right here because I was trying to get it in the club.
and I guess drinking while DJing, right?
No, he said he wasn't. I mean, you talked to him. I wasn't there. It was DJ Sidney Ray, October 31st at this place, and that was the day in question. And then this is this one, I'm sorry.
Okay, so
October 27th.
I have here that you're consuming alcohol. I have here that the consumption is October 26th,
Yeah, that's it bleeds in.
October 30th,
And November 9th.
November 9th. Oh, and
Things explode here. Mr. Imam is hit with allegations of drinking while on bond. His excuse? The alcohol detection came from makeup. The judge's eyebrows practically fly off. Body cam data, event photos, DJ schedules, everything's on the table, and it's getting wild. The court isn't buying the cosmetic defense, and the judge's disbelief is turning into something far more serious. This is where the courtroom goes from skeptical to stunned.
October 9th. So
That was, yeah.
I have 4 different events that you're consuming alcohol.
For October 9th, Your Honor, that was whenever you told me to put the scram on, and I put the scram on right after that. And then those other 3 dates.
So you're allegedly consuming alcohol the day I tell you to put it on.
No, he did it that's the day, and then he put it on. No, that's the violation. We addressed that.
I have a positive for alcohol on the 9th of October.
Not from the scramble thing.
Yes.
October 26th.
I sent him on 10/9. So Felicia,
Yes, Judge.
so we sent him for a POC test on 10/9 on that time. Did he test positive for alcohol?
Yes, Judge.
Why on earth are we just now getting the violation?
The violation
No.
was already addressed.
That was addressed.
Yes, that violation was already addressed in a previous BVR. They started to put it in that section, that's why I didn't highlight it. But
Did I address that BVR?
yes, and that's when we amended the conditions to put a scram.
Okay, so now we have alcohol consumption as a second violation on top of all this.
For the scram itself.
I've been very grateful for the second chance you gave me. That was from the makeup that I applied to myself, and I was just ignorant to the fact that that would actually set off my scram device, but I have not consumed another alcohol beverage at all. Those are also the days that I was working, I was entertaining. I did not consume another alcohol beverage at all, so I've been very grateful. I'm not stupid. I wouldn't consume another alcoholic beverage after you put the scram device. in the
Mr. Burrows, I told you at every single stage of this game, do not put anything into your body that could be positive for alcohol. It is your responsibility to know what you can and cannot use. You're old enough to know that actions have consequences.
Yes,
And
sir.
here we are. I've already let you go one time with a positive for alcohol. When I told you not to consume, you literally tested positive on the day that we sent you for the test. And now we have another 3 positives for alcohol.
I don't think that's all, that's the other parts, yeah, but the first part, that's not, he didn't test positive.
He tested positive 10-9.
No, that was,
It was a positive urinalysis test, and because of that, we amended the.
And because of that, I amended the conditions. I did not put him in jail. I put the scram on him.
yeah, but we addressed that he didn't go in and like.
I got it.
It's not 2 tests, is what I'm trying to say.
Okay.
You're right.
But he's continuing to consume.
So, yeah.
Stephen,
The scram reports are also in your email. I'm not sure if you viewed them, but we got the ratings and the records as well for all of those dates.
have you seen that?
I have whatever I was sent yesterday.
That's it.
I'm sorry, Mr. Bros. What am I supposed to do? Just let you go again?
No, sir, I'm not asking to, and I did not consume any alcohol. It was just yes, sir. The products that I put on, and I just was not aware that that was set off that. And it was makeup, sir. That's all it was. I didn't consume an alcohol beverage at all.
That party is 10:31, and I have.
The judge locks in and lays out the timeline, October 9th, 26, 30, November 9th, showing a pattern of alcohol violations. Mr. Imam insists it's all makeup, TikTok cosplay, and sweat. But the court's not having it. A 0.08 blood alcohol reading is the legal limit, and the judge simply doesn't believe that comes from face paint. This is the moment where excuses die and consequences come knocking hard.
Here, 10:26, 10:30, and you're telling me that you put this makeup on November 9th? Is that what you're trying to tell me?
Yes, sir. It's for my TikTok, and I have the videos of it also, sir. I do cosplay, and I just put on those products, and that was the sweat from it. I had no idea that that would actually get inside my blood system and and set that off.
You have levels?
Yes, they're in the scram report.
What is it?
I have.
It's like a peak of 0.08, and then.
He's a 0.08.
Yes.
You're telling me that makeup made you a 0.08?
Yes, sir. And those are the days I was at work.
I don't believe it for a second.
I even had.
I don't believe it for a second. I'm sorry. A
I understand.
0.08 because of makeup?
Yes, sir. I understand. I promise you I have not consumed alcohol at all.
I'm sorry, dude.
I understand.
That's it.
Yes, sir. I understand.
With you.
I understand. Yes, sir.
And possibly believe that makeup is going to make you as intoxicated as having 6 to 8 drinks. Where's mom? Are you mom? Come on up, mom. Thank you so much for coming. I want you to understand that the last time we were here, your son tested positive for alcohol, and I told him that there was absolutely just no tolerance. And I advised him to know what you put in your body, because it doesn't matter if you test positive. I go through a whole spiel: tequila, lollipop, hair dye, just cakes, candies, foods, gums, energy drinks, whatever it may be. You test positive, I'm going to end up revoking your bond. We've already asked him once. I put a monitor to ensure that he's not consuming alcohol. This is not the first time we were here with the DWI. We're here yet again on another one. I understand that the other one was dismissed, but I guess it wasn't enough to catch his attention, and now we're here yet on another one, and he's continuing to consume. And it's not just once, it's not twice, it's not thrice, it continues to happen. So as a result, I have to show him that we mean business, and as a result, I have to put him in custody.
I've been on him, and I know hasn't been drinking, but I can't argue, but I know he hasn't drank.
He has to know that you're on bond for a very serious case. We've asked you and told you not to use anything that has alcohol in it. And I cannot believe that makeup will cause you to be a 0.08. That's literally the legal limit, 0.08. That's usually someone consuming, a typical drink is around 0.02. So to get to a 0.08 in whatever, based on time frame and everybody's different, but it's a lot. So I'm sorry, ma'am. That's why we put him in. Mike, I'll set the bond at 5,000. I don't know, what's it at now? Okay, I'll set it at 5,000 too, so it's not. And then we'll see, you know.
Here's the final blow. The judge brings in Mr. Imam's mom and delivers a powerful message. Second chances only go so far. With multiple alcohol violations and a court clearly out of patience, bond is revoked and reset at $5,000. The message is crystal clear. Play games with the system, and you'll face the consequences. Don't forget to like the video, subscribe for more real courtroom drama, and we'll see you in the next one.